Stress? Don't be stressed.
Yeah.
Don't be stressed. This thing is never anything on the floor.
That's fine. Then I go to office and he can start paying for one.
Yeah, it was a freshness for me.
No, no, I don't know.
I went to
When my back is with you.
Yeah.
I think, oh, there is.
Yeah.
Let's move to the driving.
Okay. Lakini swali
We should all the best. May the best team win. And the other team. Hata what about it? You only look at you. This one you can sit.
yeah, because I will be looking there. Sounds. You can sit over there.
Do this.
That's right. Just no man is if it's on practice. Really? No. We don't have
Doris, join this. What was it?
do this. So before this, put one for prosecution first on top of.
These are the things for time.
I have them.
Yes. Not that one. This one. The one down. Don't have more than 2 years. Come down.
It's going humanitarian. What's it? Only this one.
Only this one. You're sure?
This one. Is it connected to?
There's no construction and defense system. I thought brand rights. We use
Networks. Different universities they compete. Sure, now this skills. Can you manage to be a prosecutor? Under the police. Can be one judge, you can be the other judge. Good skill. Patricia, where's Patricia? Come on. That there is different something. I don't know if you ask who is on which one. You can use Bible to write it, but let it be kind of legible. Yes. It's not your 20 minutes you are wasting like that. That's for plain paper.
No, they have given me already harder.
No. Like ask for a plain paper.
I have this, so
No,
that one is okay.
it's okay. Let's give it. Once I have that thing,
Let me try calling you.
I said, like that. Oh, this is just a piece of it. No, I didn't. You said, why is it? So, right. Why am I and accents? Still like This is too much. This is too much. Look at me. This is
No.
This is normal. Are you sure? Smile. Let's smell it. Let's really go on. I speak so. Minute. Tell what you know. Every sort of insight. There's also tell the same. Just find out.
It's 49.50.
If they don't get something, such a shit. Everybody so thanks. Yeah. So much. Yes. Yeah, it wasn't me. How the question is answered. Can I rephrase? Understanding this work is out of the
It's good.
The thing is, I have to be there for some. You're supposed to read the things right now. I'm going to read this. Because I read this and this. So now you're supposed to read it. So like you.
Good. But I want to hear. I have my own self removed. Then forget my notes. Okay. Good. That's okay, no problem. This is problem. It's okay. So, number 3. So, let's say number 6. Number 6. Give me.
Good.
In this game, I'm not switched. This book is.
Come on, just you and me. That's the couple.
Amekuja na penzi wa judges. You call me to submit it. Hakuna penzi wa judges. Salamu. Vunja kitu tafadhali.
I don't go to the big bus system. The one that is Wi-Fi. I don't go to the next day. You do this. This is
Extra.
borrow funds. It got to next week, like his own way is coming. So Stevenson is going to help him keep them.
But you can keep it alone, right?
That's what they say.
Okay. I need 3 pens. Anyone with extra pens? Take with 3 pens.
It's okay. It's okay.
Okay. Yeah, this. Yeah, of course. Yes. Yes. No, it's okay. We will get. Yes.
On the pattern.
But yes.
This is what they want to be they also even pay for it.
They want to.
All of you. So the first group is the defense. I mean the prosecution will come. After every 5 minutes they want to release.
Give me a son, he does anything. To his window.
This is what I putting it on silence. It doesn't close it.
I put in the name.
Stevenson, you call this Michael?
Swale. Yeah, Patricia for myself. It is not bad. It is bad. So,
She was taking some of your point to keep time.
What do I think is that something? I like it. You already yes, one time. Sample, sure. It is alarm. When you said alarm, yeah. Oh, I didn't remember.
Give him the phone.
We had it.
You give him. Stevenson,
no, normally he is on drop the
coach me. Tell him to come and use the phone steps.
still. Because usually when plan for 3 but I said the he's just like so he doesn't play big role. Fortunately, the of them for him, his job is just to squeeze the students a bit and go out the questions. Crossing is okay, but we cannot get
Tell him to come and see. Come and see. You're supposed to come and sit already.
Last year, it was unanimous.
Yes, the main phone, the main phone. So he's wasting.
Most times, especially
Stevenson is moving on, stop with.
For him.
Ray, still before one. Because most times I think, yeah, let's check. Let's check.
They were to come in? Yes.
Can we get ourselves seated so we can start?
My God.
Where's Stevenson?
You can see Stevenson. You sit down. Stevenson is resting there.
Stevenson. Stevenson. If he's not there, you sit on the bench.
You sit and do it. Sit.
You can't present. Does he know how to do it?
Yeah.
You've done this before. Yeah.
Okay. After every 5 minutes, they want to be reminded.
All right.
So when you're speaking, you just have to you switch on your microphone and you should. Okay.
Abigail, you have that? That's why you need to pay attention.
I was saying that when you're addressing the court, you have to speak on the mic. So you just switch it on, and then you're able to address the court. Yeah. When you're done, you switch it off.
And we also hope that their phones are in silence, eh? Because they can still hold in content. If it's a moot.
So in case you're having any issues with your gadgets, but we should be fine. To your extreme left is Mr. Joseph, is the IT officer of the Supreme Court. So he's going to be here with us, yeah, just to make sure that things are okay.
Thank you.
So should be coming in shortly.
You feel that need to my judges today.
Thank you.
Have you put your watch in silence?
Yeah. It was him setting it.
No, it is okay.
Keep going here. Where is my phone?
Every time, if they're asked a question, you pause the time.
Okay.
Start with 15, 10, 5. All rise. The African Court of Justice and Human Rights is now in session. President Justice Mike Chibita and the Honorable Justices Tracy Navale, Patricia Baka, and Swale Wangyo presiding. The case before the court is a situation in Amoti. The parties are the Office of the Prosecutor versus the Defense, General Chikumbi. The prosecution and the defense are each allocated 35 minutes to present their pleadings.
Yes, good morning, all. Are we ready to begin? Who has the right to begin? Okay.
May it please this honorable court, Your Honor, appearing before you is Omera Laura Bina, first counsel for the prosecution. Alongside me is my co-counsel, Jacob Wondor. We appear together with the defense, with their first counsel being Ms. Abigail Shali, and the second counsel being Mr. Salas Yuki. Within the next 16 minutes, I wish to establish two key findings. That one, this court merits jurisdiction. And secondly, that the case before this honorable court is admissible. My co-counsel, Jacob, will use 17 minutes to establish that one, the type of conflict before this honorable court is an internationally bad conflict. And secondly, that there are reasonable grounds to believe that the defendant, General Chikobi, is criminally responsible for the war crime charges profiled against me. We wish to serve 3 minutes for rebuttal. If I may proceed. Much obliged. Your Honor, The case before you is about an individual who wishes to prioritize his selfish political interests and eliminating it as patriotism. This individual recruits and trains children and engages them in active hostilities to commit grievous war crimes against innocent civilians. This individual allows these children to not only suffer such atrocities, but also to have young self-patriots suffer sexual crimes, including gang rapes, forced sexual slavery, and forced marriages. But the most aching bit for the prosecution is the efforts that the defendant state has employed to bring the defendant into criminal responsibility. We submit that the defendant state had done nothing in regards to this matter and has let the defendant escape criminal responsibility. We beseech and suffer this court not to allow such a matter. On the first issue of territorial jurisdiction, we contend that this court merits all the four facets of jurisdiction, being subject matter, temporal, personal, and territorial jurisdiction. I shall proceed to territorial jurisdiction as it is the contended jurisdiction in issue under the first person. Our premise is that this court has territorial jurisdiction. To begin with, I wish to paraphrase what the Fiae Chamber 3 in Bangladesh versus Myanmar of 2019, paragraph 45 reasoned when it comes to territorial jurisdiction. The court reasoned that one, its premise for exercising territorial jurisdiction is to exercise jurisdiction over the crimes in issue. That's the first thing. To do that, it has to establish the location of the crimes in issue. That's the crux of the matter is, where is the crime in issue? Our contention is that the crimes in issue happen in a multi-area, a territory that is linked to the state of Malawi.
Excuse me, the case you quoted, is it binding on this court?
Much obliged, Your Honor. I cite all cases on the Swiss grounds. Much obliged. That leads me to the first premise of our limbs of argument in regards to this issue. We contend that a multi-territory is a territory that is by fact linked to the state of Malawi. Our contention is premised on the fact pattern paragraph 6, where we are introduced to where the territory of Amuti is located. Rather, the state of Amuti is located on the outer edges of the territorial sea of both the state of Kibara and the state of Malawi. This means that the sovereignty over the Amuti territory is not exclusively left to the of the states. However, the statement of President Danjuma under the fact pattern paragraph 8 evidences that for a while, both the state of Malawi and the state of Kibara have been exercising sovereignty or rather administration over the state of Malawi, over the Amuti territory. And this goes to proceed to show that at the time when the President Danjuma was claiming exclusive jurisdiction over Amuti territory, it was a territory that was linked to both the state of Malawi and the state of Kibara. We thus contend that because
why in the past do you get the part in which it was being administered by both states?
Much obliged, Your Honor. Our contention is that at the time when the state of Kibara was claiming exclusive jurisdiction over Amuti territory, President Danjuma's statement provides that the Amuti territory was a territory that was shared between the state of Malawi and the state of Kibara. That's our contention is Amuti territory is a territory that is linked to the state of Malawi and this court found different territorial jurisdiction.
But there is a question that seems to appear, which was the question of sea level rise, which the claim by Kibara is that the Amuti area is no longer part of Malawi, but now it is part of Kibara. So how do you liaise your argument based on this statement by Kibara?
Much obliged, Your Honor. What I submitted in the first place of submission. Your question leads me to the second link of my submission, last matter. And my contention is that baselines, as have been contended by the defense, cannot shift by law. We contend that Aguero The claims can shift on facts, and that is not contained under the facts pattern paragraph 7. However, what this court needs to consider is, can deadlines by law shift? Your Honor, I would wish to persuasively rely in verbatim on what the International Criminal Court of Justice, in the International Court of Justice, rather, in the limitation of the Gulf of Mining of 1984 between Canada and USA, reasoned under paragraph 112. It mentioned that no maritime delimitation between states with opposite coasts may be effected unilaterally. And it mentions that it can only be effected if there is an agreement in good faith between these two states, or by relying on actual rules of international law. We contend that under the fact pattern paragraph 8, at the time when President Dan Juma was claiming exclusive jurisdiction over the territory of Moot, it had not consulted, it had not gotten into an agreement with the state of Malawi over this issue. Secondly,
yes, but as you noted clearly that it is not only purely on the question of an agreement, but also it can be under the rules of international law. And if a reading of Article 5 of the Convention on the Law of the Sea seems to indicate that the baseline is the lowest low water point. So if there is shift in that, doesn't that then mean the baseline has shifted? If the geographical change is in existence.
Much obliged, Your Honor. We do not consider that there are physical realities that can actually affect the course of the geographical states. However, we contend that insofar as the limitation and consideration of maritime boundaries is concerned, we do not look at the physical realities of the issue, but we look at what does the law provide, as at the time when the maritime boundary issue was delineated at first before the condition issue arose. And the condition is that before the state of Ibarra claimed exclusive jurisdiction over the Amobi territory, there was already a territorial sea agreement, and that is in regards to paragraph 6. Therefore, claiming unilaterally that it has exclusive jurisdiction over the territory of Amobi goes beyond its mandate state and its obligation. Much obliged, Your Honor. That leads me to conclude that the state of Malawi does have territorial jurisdiction over Amobi territory, and thus this court can exercise territorial jurisdiction, being that the state of Malawi is a member state to the Malawi culture. Your Honor, further, under Article 46, it is contained by the Constitution that in the event that this court will not persuade on the state on the Amobi territory being attained to be linked to the state of Malawi, it can still exercise jurisdiction on the basis that the victims in issue are actually nationals of the state of Malawi. And in fact, pattern paragraph 13, we have evidence to the extent that 250 citizens of Malawi were affected by the attack in issue. 51 of them became casualties, and all of these are victims linked to the state of Malawi. In the interest of time, I will proceed to the second issue of contention.
But we have crimes that are committed on board the ship. Does this court still have jurisdiction for those crimes?
Much obliged, Your Honor. The court will still have jurisdiction over crimes being right. Still under Article 46, it can exercise jurisdiction if the accused person in issue is a national that is a member state to the Malawi Protocol. And we contend that General Chikumi, as at the time of the commission of the crimes, was a citizen to the state of Ibarra, and that is evidence under the fact pattern paragraph 4. Thus, this court can still exercise jurisdiction.
But Ibarra was not state party at the time.
Much obliged, Your Honor. That guides me to that guides the submit on the issue of temporal jurisdiction. And on the issue of temporal jurisdiction, under Article 46E of the Malawi Protocol, we are looking at the time when the alleged crimes in issue were committed and the territory in which the crimes in issue were committed. We submit that the territory within which the crimes in issue were committed was a Moot territory and as have been established as territory linked to the state of Malawi. And as at that time, the state of Malawi was a member state party to the Malawi Protocol. That temporal jurisdiction is also related. That leaves me, if the court allows me to proceed to the second contention. Our second issue in contention is that our second issue in contention is that this case is admissible before the Supreme Court. Your Honor, our first premise in regards to this issue is to establish and reason as was reasoned by the pre-trial chamber in the International Criminal Court, specifically in the case of prosecutor versus General Court in Acts 2009 rather, under paragraph 34. That court established that the purpose for establishing admissibility is to determine the criterion which enables this court to determine whether in respect of a given case it can go ahead to proceed or whether it should allow a national state to have jurisdiction over the matter. Our contention is that this case merits the admissibility test as have been provided under Article 46H of the Law Protocol. Your Honor, essentially, the test for admissibility under Article 46H3, which is in relation to Article 17C of the ICC Law Statute, was reasoned processively again by the ICC court in the pre-trial chamber of prosecutor Marcus Francis Mbawa and Acts of 2012, paragraph 38. So the test for admissibility includes two thresholds. One, the complementarity criterion, and secondly, the gravity criterion. I submit that these two criterions in your order will inform the views we have raised. On the first issue of complementarity criterion, Your Honor, Article 26H allows this court to exercise complementary jurisdiction in the event that a national state having jurisdiction fails to do three key things. One, to either investigate or prosecute or try a case in issue. Secondly, it also considers if the decision not to do either of these things was based on its unwillingness to do so. Our submission at the prosecution is that the state of Kibara has neither prosecuted nor tried nor investigated the case in issue due to its unwillingness to do so. To evidence that the case in issue was neither tried nor investigated or prosecuted, I will rely on the fact pattern, paragraph 22, where we are presented with the amnesty legislation that has been created by the state of Kibara. The state of Kibara legislates the amnesty.
How do you realize that argument you are making with the legislation in State of Islam Gaddafi before the ICC, in which the pre-trial chamber seems to make a position that it was sufficient, the amnesty granted under the law in India was sufficient enough in terms of the question of admissibility. So I'm thinking about the admissibility in the case of State of Islam Gaddafi before the ICC. The court seems to have taken the position that it was sufficient enough for the amnesty to be granted, and therefore the question of admissibility was not permitted.
Your Honor, when we are looking at the amnesty issue of General Shikobi against that which was provided against Mohammed Gaddafi, they have distinct features. In the case that for General Shikobi, his amnesty was given not based on the merits of the case. Secondly, the amnesty that was given to General Shikobi precludes him from criminal responsibility without any basis. On the other hand, the amnesty that was given to General Shikobi actually conditions to it criminal responsibility to General to Mohammed Gaddafi, which is not so in his case. In this case,
But the same is not that it was more of a conditional amnesty. That's actually what the reasoning of the court. It was because it was a conditional amnesty, then it was okay, rather than a blanket amnesty.
much less, Your Honor. But the conditions that were given to Mohammed Gaddafi rather were based on the merits of the case to Gaddafi. But in this case, the amnesty that was given to General Shikobi was not based on the merits of the case in issue. In Gaddafi, they considered the crimes that Gaddafi committed in the state of Algeria. But in Libya rather. But in this case, General Shikobi is given an amnesty without actually considering his criminal responsibility to this issue. When we look at Article 1 of this amnesty legislation, it begins by stating, and I'm reading it verbatim, that anyone who took part in the hostilities in Moot territory shall be granted amnesty for all activities to hostilities. And then it proceeds to say that all ongoing investigations and prosecutions will be terminated. and all criminal sanctions against him are also revoked. That means there's no criminal responsibility. Much obliged, Your Honor. If you allow me 2 minutes and last conversation.
Okay, you have 2 minutes, and in addition to what you're saying, those 2 minutes, what is the legal found applicable to what you have just been doing to us in that case? When you're concluding, you just giving me a legal time that is applicable to what you've just been doing in that case, in relation to the facts here.
Much obliged, Your Honor. Finish up on that. We contend that there's no criminal responsibility that is attached to the investigative agent. And as such, Article 56, page 3, in the event that a state fails to, act against a person who has committed such great atrocities and absolving from criminal responsibility, then action by this honorable court is warranted. As such, is the meaning of this case is at this point. Your Honor, I am not sure whether I understood the question, but I ask that you can please speak for me.
It's okay, it's okay.
In the second material, I bear that this court was judicial economy.
May it please the court, as earlier introduced, my name is Jacob Mwendo. I am the second counsel appearing on behalf of the prosecution. And in the next 17 minutes, I'll demonstrate before this court that there are reasonable grounds to believe that General Chikumi committed the war crimes as charged. And I'll also demonstrate that the general committed this crime on the basis of command responsibility. I'll also seek to address as to the nature of the conflict. But before I do so, honorable members of the bench, as we sit here today, 51 lives have been lost. Women and children as young as 13 years old, 14 years old have been raped. These atrocities have caused them severe psychological and physical harm. Property in the Moot area was damaged. In fact, a water desalination plant was destroyed. Therefore, we ask this chamber to confirm the charges against the general. Let the case proceed to trial. I now address the question of the nature of the conflict. It is the submission of the prosecution that the conflict in Amuti was an internationally armed conflict. The basis of this is common Article 2 to the Geneva Convention that provides that internationally armed conflicts shall be recognized where the convention applies to the high contracting parties. Indeed, this was reiterated by the appeals chamber in Prosecutor Principal Verdict in 1995 at paragraph 80 that armed conflict exists when it is international when the armed conflict involves two states. We submit that it involves the state of Maravillo, pursuant to paragraph number 1, and the state of Kibara, pursuant to paragraph number 2. We are aware that there may be questions as to whether the state of Kibara was involved. We submit that indeed it was the state that was involved. When the demonstrations began from the 2nd of April, from paragraph number 10, 11, and 12, we see that the KSF assumed governmental functions. They act on behalf of the state of Kibara. They operate from the capital, city, Abbey Street. They proceed and recruit members into their armed forces. General Chikumi issues an address from the presidential office and saying that they are ready to defend their nation. These actions constitute governmental actions. Indeed, as Malcolm Shaw notes in his book on international law, from pages 336 to 341, governments will be recognized on 2 criteria: if they have democratic legitimacy and if they have effective control over the territory. We submit that the KSF exercised effective control from the time of the demonstration up until when President Danjuma was reinstated, and they had democratic legitimacy. When you look at facts,
Before you move in, Yes, please go ahead. You just quoted a book.
Yes.
What weight of authority does that book have on this court?
Much obliged, presiding judge. Article 31 of the protocol to the statute of the African Court of Justice and Human Rights provides at clause E that the writings of the most highly qualified publicists will be applied by this court on persuasive grounds.
Why do you think these highly qualified people?
Much obliged. Malcolm Shaw has been cited by numerous ad hoc tribunals to establish is an author in public international law. He has been quoted by decisions before the ICC, before the ICTR, to eliminate issues such as this before this court.
Thank you.
Also, 1 minute before you say, any example of the cases like that's what has been cited for us to take note of? Thank you.
Much obliged. Whereas I may not direct the court to a specific example, I am aware that Malcolm Shaw has, in his book on public international law, designates these specific elements of which shall be applied, and this code is only to be persuaded. It is not binding on this code to be persuaded.
Yes. But Malcolm Shaw actually that specific page which article 11 of the Act of Social Responsibility, which requires the effective control requirement. However, in Article 11, it only requires when there is no government at all. But in the situation we have government.
Much obliged. Indeed, I take
A group of persons that exercise an element of governmental authority in the absence of a government, then their action shall be attributable to the state. But here there is no absence of government, there is government.
Much obliged. I still to separate that there is a government, but the government is not in a position to exercise its de facto control. Indeed, when you look at fact paragraph number 10, you can see that some of the ministers in the government of President Danjuma have resigned. The president has moved to an underground bunker. The president cannot give a speech when the country needs it. The president is not able to act to expel the invaders. General Chikumbi is able, within his forces, to expel these invaders. So he is acting.
So are you trying to tell the court to recognize a de facto government rather than the de jure government in the states of Kibara being the party to the conflict?
Much obliged. That indeed is the submission of the prosecution.
What is your basis for that?
Much obliged. The basis for the arguments of the prosecution is based on a case that was decided by the U.S. Supreme Court in the case of Guarantee versus the U.S., which is applicable on persuasive grounds. We submit that the court noted that the issue of recognition of government is based on democratic legitimacy. This government that is de facto is recognized by a majority. When you look at fact paragraph number 12, a majority of the people in Kibara actually recognize this government. President Danjuma is only recognized by those from his own region and not a majority of them. So when you look at everything,
The fact saying that. The fact does not say that.
much obliged.
It says yes, that is only recognized by the region, but we don't know the population of the region. Maybe they are majority.
Much obliged. If I may get this quote further from fact paragraph number 12, we see that President rather general, that is General Chikumbi, is being if I may read in verbatim so that I may guide my persuade the further. Yes. This led at the tail end of fact paragraph number 12. This led to confusion among the populace divided between supporters of President Danjuma, who were primarily from his own region, and those rallying behind the KSF, with the majority in support of the KSF. Much obliged. I will now proceed, having demonstrated that this is an internationally armed conflict, I will now proceed to address the issue of command responsibility. Article 46b3 of the Malabo Protocol provides that superiors will be responsible for actions of their commanders if they knew, if they acknowledged, if they had a reason to know, and they failed to take up the measures to prevent and punish the perpetrators thereof. Command responsibility under international criminal law is premised on three grounds. The first one is the existence of a superior subordinate relationship. The 1986 commentary on additional protocol 1 or on Article 86 of additional protocol 1 provides that a superior subordinate relationship will exist if the superior exercises some elements of control over its subordinates. We submit that the General Chikubi, person referred to paragraph number 494, was the leader of the KSF. So he was in a position to exercise control over his forces. The second element is that of knowledge or a reason to know. We submit that the case of prosecutor versus Jermaine Katanga at the trial chamber in 2014 at paragraph 777 interpreted that knowledge means awareness that a circumstance exists in the ordinary course of events. When you look at exhibit number 1, which you have brought before this court as evidence, it shows that the general was in knowledge. Actually, weekly reports were being submitted to the general. Therefore, this should have been put in knowledge. Even if the court is
Sorry, I can back on the superior subordinate relationship. Because the requirement there is that the superior must have effective control over subordinates. Now, I'm wondering how General Chikubi had effective control considering the distance between where General Chikubi was and where the family, the minister was. And how do you liaise that with the benefit of jurisprudence, especially the appeals chamberization that talk about the geographical distance between the general and those who were in charge on the ground, because Denver was in the Democratic Republic of Congo, the generals were in the Central African Republic, and that was the basis of actually appeal. So how do you liaise the issue?
much obliged. Indeed, we are aware that Denver was acquitted because they were in a different country. However, we submit that the general was in information. Information was liaised to the general. He was not present at the exact place where these crimes were happening, but exhibit number 1 shows that information was sent. Text messages were being communicated between the general and Colonel Delich, who was leading the operations on the ground. Therefore, with this information, a superior subordinate relationship exists. And in fact, I shall proceed now to show that if the court, even if the court is fascinated by the question of knowledge, commanders are required to have a reason to know. If they have a reason to know of the actions of their subordinates, then they are responsible. As the trial chamber of the ICTR observed in prosecutor versus Bagilishema, a reason to know is the existence of some general information on the part of the commander to put him on notice. So exhibit number 1 should have put the commander on notice that his subordinates were committing atrocities. In this weekly report, it should have inquired from the subordinates what actions are you undertaking in the Moot area. Therefore, we submit.
Number 1 is very clear. He seems to inform Colonel Davis that please make sure that the unpacked is behind.
Much obliged. Indeed, exhibit number 1 shows that. But the general has information on him that crimes are happening. That what the general should have done is inquire from the government, what are they doing in making sure that they behave. What are they doing? Because he is the general, he is the leader, he is the topmost commander, he has this obligation. He cannot rely on his negligence to inquire about the conduct of his forces to take responsibility. I shall now proceed to the last element of command responsibility, that is failure to take up the necessary measures to prevent and punish your subordinates. We submit again the case of Prosecutor Musema before the International Criminal Tribunal for Rwanda in 2000, where at paragraph 808, the court observed that Mr. Musema failed was in a position of control over his forces and was in a position to prevent and punish these crimes, and therefore he was criminally responsible as a commander. We submit in this particular case, as I have shown, the prosecutor was in effective control over his forces. He should have exercised the necessary measures to prevent these crimes, but he did not exercise that mandate. Additionally, he failed to punish soldiers of the particular crimes. And therefore, it is the submission of the prosecution that command responsibility exists. I shall now proceed to show the specific war crimes. It is the submission of the defense that we are charging the general on the basis of command responsibility, and we are at the pretrial chamber. What is required at this stage is reasonable grounds to believe. Indeed, the pretrial chamber in Prosecutor versus Lubanga in the year 2007, at paragraph 39, emphasized that it is the role of the prosecution to present evidence before this court to demonstrate a clear line of reasoning that to commit the accused person to trial. I shall demonstrate within the evidence that we are presenting today before this chamber that there exists a clear line of reasoning to commit and concrete evidence to commit the accused person to trial. The first count is that he directed attacks against civilians and against persons taking no active part in hostilities. The case of Prosecutor of Blackfish before the International Criminal Tribunal of the former Yugoslavia in the year 2000 designated the elements of an attack against civilians. It includes an attack directed against an object that is not a military object. Additional Protocol 1, Article 52.2, provides that a military object is an object which offers a definite military advantage. Let us examine the CMN liner, which is the object, the forces of the general attack. The CMN liner, you can see from paragraph number 13, it was moving slowly. The CMN liner was bearing the flag of a state and not a military flag. Therefore, it was an attack against an object that is not a military object. Again, the mental responsibility or the mental responsibility for the general is engaged, which is knowledge. As I have shown under
Can we term this as a mistake of fact?
much obliged. Indeed, we cannot time this as a mistake of fact because a mistake of fact needs to be honest and reasonable. We submit that they fail to exercise precautionary measures that are required under the additional protocol. Precautionary measures under the additional protocol, Article 57 of Additional Protocol 1, especially Article 57.2c, provides that attackers need to issue warnings. What was issued here is an order to stop. We submit that an order to stop is insufficient. It is not the feasible measures in the circumstances. A warning would go further as appraising the other party that there exists danger. This order did not show the other party why they need to stop or how to stop. It only told them that they need to stop. Surely, there is no obligation on the ship to stop because they did not appraise the existence of danger or the existence of risks. These measures were insufficient as precautionary measures. Much obliged. I shall now proceed to the second element, to the second war crime rather. That the general and his forces committed rape, sexual slavery, and other forms of sexual offenses constituting a grave breach of the Geneva Convention.
Sorry, I'm wondering whether this is actually a war crime. And my point here is who committed the war crime?
Much obliged. The crimes were committed, pardon to fact, paragraph number 18 and 19, by soldiers of the general, soldiers against fellow soldiers of the KSF.
So, because one of the criteria required, one of the elements required for war crime is that it must be, a conduct that took place in the context and as it was associated with an armed conflict, either of international or international, since you categorize it as an international. But this does not seem to be associated with the conflicts because it is one are soldiers from the same armed force who seems to commit a crime against the same soldier. So it does not, it is not associated with the armed conflict. So can there be a war crime without an armed conflict?
Much obliged. Indeed, that was the reasoning of the court in prosecutor versus Ndagana. The appeals chamber reasoned that there is no distinction in cases or in war crimes of sexual violence that they can be committed against fellow soldiers. But of interest is actually the trial chamber's finding at part paragraph number 79. Actions of rape, actions of sexual slavery, which prey on the fear and deprivation of victims, they cause severe psychological and physical harm that renders these victims temporarily incapacitated and therefore hors de combat. And when they are hors de combat, it means they cannot be attacked because they are protected under IHL.
How then do you liaise the international jurisprudence with the roof case before the Supreme Court of Sierra Leone, which says totally different, that crimes committed against the same members of armed forces will not amount to war crimes?
Much obliged. Indeed, the principle of international law, the principle of lex posteriori derogat legem priori, requires or provides that the most recent jurisprudence will repeal the older jurisprudence. And therefore, this court ought to be persuaded by the findings of the Ndagana case.
So, I would like to know whether the international humanitarian law applies to members of the same group, like an armed conflict. The members of who are standing together, the same does the international humanitarian law apply to them?
Indeed, and that was the finding of the appeals chamber in prosecutor by Ndagana. Seeing that my time is up, I request for an additional 3 minutes to wrap up my submission.
You come up with your.
Much obliged. It is the submission of the prosecution in the case of prosecutor by Ndagana, the trial chamber observed that the elements of rape include penetration, coercion, force, and intimidation. For penetration, we have presented a medical report before this court to show that indeed there was penetration. And from fact paragraph number 18, we can see that this penetration was committed by force. This penetration was directed against soldiers incapable of giving genuine consent. Permit me to rely on the ICC rules on the procedure of evidence. And because this court is yet to enact its own rules on evidence, we seek that it be persuaded by the ICC rules. Rule 63.4 provides that there is no need for corroboration for sexual crimes. Additionally, the case of prosecutor versus tobacco before the trial chamber of the ICC in 2013, paragraph number 28 ruled that there is no rule against hearsay evidence. We submit, therefore, that this evidence we submitting before this court has been corroborated. There is no rule requirement that it be corroborated. The evidence has been corroborated. The evidence of the report by the FIAE has been corroborated by the evidence of the video of the Danish Express. We submit, therefore, that the evidence be admitted. And also the court be aware that we are a pre-trial chamber. This is not a trial. This is a pre-trial. We want this court, or rather we request from the court, to commit the person to trial, admit this evidence, and let the case proceed to trial.
Where did the evidence come from?
Much obliged. The evidence came from fact paragraph number 18, shows that the evidence came from an independent association, media association.
So how then do you liaise that with the Katanga jurisprudence where they say media reports can only be used to initiate an investigation for the purpose of confirmation of fact, but not for the confirmation of charges?
Much obliged. Indeed, we are aware of the Katanga decision. We submit that that is not the only evidence we have before this court. We also have we also have medical reports before this court to confirm penetration. This is actually expert witness.
Medical report from the media.
Much obliged. The medical report is from the legal press.
Yeah, media.
Yes, and therefore it is the submission of the prosecution that The FIA report corroborates the media evidence by the New York Press. And because, as I reiterate the case of prosecutor, the case of prosecutor versus Dubato, there is no rule against hearsay evidence. So hearsay evidence can be admitted for the purpose of confirmation of charges. Much obliged, I shall quickly summarize the last war crime, that is UCS civilians.
Time is up. Can you now make your prayer?
Much obliged. The prayers of the prosecution are that the prosecution admits that it has, the court admits it has jurisdiction. It proceeds to admit the case and that the invocation of amnesty is inadmissible. Finds that there are reasonable grounds to believe that the general committed these crimes and confirm charges against the general. The prosecution hears their case.
Thank you. We now quickly move over to the defense.
Much obliged. Greetings, Your Excellency. May it please the courts. My name is Abigail Shali, appearing as the first counsel for the defense, and I'm joined with my co-counsel Sarah Sparuki, and we are team at 25 FIM 2594, and we shall be using 35 minutes of this court's allocated time to us to address on the three issues before this court. And I shall be using the first 16 minutes to address on the first issue on jurisdiction and the second issue on admissibility. And my co-counsel shall be using the next 16 minutes to address on the third issue. And we shall be reserving the last 3 minutes for our rebuttals. With this court's permission, we'll let proceed. Your Excellencies, we do console with the families that lost the 51 people, and we do deeply, we're sorry to the sexual violence victims. However, Your Excellencies, in the aftermath of an armed conflict, international justice must not be rushed. It must be deeply rooted in law. And so before this honorable court can decide or weigh on guilt or innocence, it must first ask itself, do we have the right to decide on this matter? So as the defense, we respectfully submit to this honorable court that this court lacks both the grounds of jurisdiction and admissibility. And we shall justify this through our submissions. On the first issue on jurisdiction, we do agree with the prosecution that the African Court to exercise jurisdiction, it must satisfy the 4 dimensions of jurisdiction, that is personal jurisdiction, territorial jurisdiction, temporal jurisdiction, and subject matter. However, as the defense before this court, we do submit that this court has no territorial jurisdiction and temporal jurisdiction. On territorial jurisdiction, Your Excellencies, it is provided for under Article 46 BIS of the Malabo Protocol, where it gives a clear attribution of territory in question, that the African courts must be, before an African court exercises territorial jurisdiction, it must first exercise, or rather give, or rather provide that there is a clear attribution of that sovereignty of the territory in question. Your Excellencies, before determining maritime baseline, because it has a direct bearing on territorial delimitation, as it is provided for under Article 5 of the United Nations Convention on the Law of Sea, whereby it provides that for normal baselines to be measured, it is measured from the low water mark. And also, on Article 15 of the United Convention on the Law of Sea, where there is no agreement between the adjacent states, it shall be guided by the median line. And so, Your Excellencies, if you may move with me to paragraph 8 of the facts pattern, where we see President Dajuma ascertaining that the climate-induced sea level rises, it shifted the baselines of Kibara and Marawio, but it exclusively placed the Amuti area into the jurisdiction of the Republic of Kibara. We also...
Does Article 5 of the Global Sea Convention apply here? Because these are 2 adjacent states. And therefore, a normal baseline cannot be used. It's only Article 15 that applies.
Much obliged. Article 5 is the baseline to show it is the basis of our submission that the normal baselines have to be measured from the breadth of, or rather the breadth of the territorial sea, that is the low water mark.
Which is my point. Article 5 does not apply to adjacent states.
Yes.
Under the Convention on the Law of the Sea, when you look at the commentary, where the adjacent states, Article 5 does not apply. It's only Article 15. So you cannot base your argument on Article 5, considering that Kibara and Marawio are adjacent states.
Much obliged. Maybe to further my argument on that, Article 5 was the basis. Like it was to show that the measuring starts from the lower water mark, but our submission is that we use Article 15 to show that there was a shift of the waterline benchmark due to the climate change, that is the sea level rises.
I don't know if you understood my question. We have three types of baselines here.
Yes.
We have normal baseline, okay? Then we have Article 7, and then we have Article 15. So each article can be different. So it's either you say it's only Article 5, or Article 7, or Article 15. So you cannot use Article 5 and Article 15 together. It has to be one. That's my point.
Thank you. Much obliged, Your Excellencies. Then we wish to rely on Article 15 in that case. Furthering our submission, on paragraph 6, the last statement, we do see that there was the Kibaran, the Republic of Kibara has been negotiating concession agreements with regards to the Amuti area. So, Your Excellencies, this demonstrates that the Republic of Kibara had the economic and regulatory control because of the agreements that they were making. And so it is our position that since we see in paragraph 6 that there was active participation of the Republic of Kibara with regards to Amuti area, and also we see in paragraph 4 that since 2002, the Republic of Kibara has been an economic government, or rather has been an economic state. So this shows the relation between the active participation of the Republic of Kibara with its economic jurisdiction with regards to the Amuti area. Also, we like to place our reliance, or rather, we like to further our arguments based on the jurisdiction of the semi-lina. It is a requirement under Article 46 EBIS of the Malabo Protocol, whereby it provides that a territory of a state extends to the vessel. And so we see in paragraph 14 of the facts pattern, whereby it is given in detail. And it is significant in our case. Article 46 EBIS of the Malabo Protocol, whereby it gives, or rather it gives the African court jurisdiction with regards to territorial jurisdiction, where the alleged crimes have happened in a territory of a vessel. So
that is registered.
That is registered under to a state party.
So where is the vessel registered?
With regards to article, sorry, Your Excellencies, with regards to paragraph 14 of the facts pattern, we do see that the semi-lina vessel had been registered by under the Republic of Kibara, under a company in the Republic of Kibara.
So at that time, if the vessel is registered in Kibara, and Kibara is not a state party, and Article 46 EB provides that it must be a vessel that is registered in a state party, so then can exercise jurisdiction over the territory of an state party.
Much obliged, and thank you for the guidance. And so that is our submission, that this court lacks territorial jurisdiction with respect to the registration of the semi-lina under the Republic of Kibara, because it is not a party state to the Malabo Protocol and the statutes.
Okay. Is the state of Kibara a party to the Convention on the Law of the Sea?
Yes, Your Excellency.
What does Article 91 say?
With that, I may wish to gain.
That the vessel is all about the space in which it flies the flag.
Mhm.
So it is not a state party to Malabo Protocol. That means Malabo Protocol does not apply. So it's applying the convention that applies to it, which is the Convention on the Law of the Sea. Correct?
Yes.
The Convention on the Law of the Sea, Article 91 says, we look at the vessel, the flag in which the vessel is flying. Which flag is it flying?
According to the facts pattern in paragraph 14, it was the state of Malawi.
Is Malawi a state party to the Malabo Protocol?
Yes, Your Excellency.
Do we have jurisdiction therefore?
Well, with regards to Article 46, we still do contend that this court has no jurisdiction, territorial jurisdiction, with respect to the same liner.
Yes, so if the same liner was flying the flag of Malawi at the time of the commission of the crimes, and Article 91 of the Convention on the Law of the Sea says that the vessel is territory is regards to the flag in which it flies, and Kibara is not a state party to Malabo Protocol, but it is a state party to the Convention on the Law of the Sea, meaning that provision will apply also to Kibara. In that sense, therefore, the court can exercise jurisdiction over the alleged crimes that were committed on the vessel by virtue of the space of the flag in which it flies.
Thank you, Your Excellency. But again, in Article 92 of the United Convention of the Law of the Sea, it also provides that a vessel shall only fly the flag of the state to which it is registered. Yes, and so it is still our position, even by the fact that given there was discrepancies by with regards to registration and the type of flag that it was flying, it was still the mandate of the or rather it is our position that the African courts still have territorial jurisdiction with respect to the registration of the ship.
Council,
Yes,
do you have any exposure to
yes, Your Excellency. We shall be relying on that matter with regards to the registration of the Seminlina. With regard to that, we shall rely on the case of Ireland versus United Kingdom in 2001 before the International Tribunal for the Law of Sea, where the court emphasized that where the registration of a vessel was considered relevant to establish jurisdiction and functional sovereignty. And so it is our position based on the emphasis made by the tribunal in that case that this court shall exercise jurisdiction with regards to the registration of the Seminlina. And onto my last submission on the first issue, it is or rather key to note that this with regards to the Amuti area, it is still unsettled before the International Court of Justice, and it remains under litigation. And so, if this court proceeds without the territorial jurisdiction, it will be violating the principle of judicial economy and comity. And so, it is our position that since this the state of Malawi had filed the case before the International Court of Justice, and it is still unsettled, it will be violating the principle of coherent judicial outcomes. Turning to our second group of arguments on temporal jurisdiction, it is our assertion, contrary to the prosecution position, that this court has no temporal jurisdiction, and it shall be persuasively relying on the principle of non-retroactivity of treaties provided for under Article 28 of the Vienna Convention of the Law of Treaties and Article 46E of the Malabo Protocol, whereby it explicitly demonstrates that African courts, this African Court of Human and People's Rights, shall only apply to crimes committed by states after they have ratified the Malabo Protocol and the statute. And so, as we see, in paragraph 13, during the violations, we see that they happened in 22nd June 2023. However, again, in paragraph 18, we do see that the Republic of Kibera had not ratified the Malabo Protocol during those attacks. They ratified way after the attack. And so,
isn't that submission based on the determination that the territory is the territory of Kibera?
yes,
So if we rule otherwise, does that argument stand?
yes.
Because if we rule that the territory was the territory of Malawi, in that case, therefore, you cannot make arguments of temporal jurisdiction.
Yes, Your Excellency. But our argument is based on the fact that if you rule the territorial jurisdiction to have be under the state of Malawi.
Okay. How then do you, if let's say we rule in your favor, that is the state of Kibera, the territory, but who are the victims here?
The victims of they were from the nationals of Malawi, and the victims of the sexual violences were from the Republic of Kibera.
So will we still exercise jurisdiction over the crimes committed against the citizens of Malawi?
No.
Because Malawi is a state court.
Can you rephrase the question?
If we rule that the territory was the territory of Kibera, but since the alleged crimes were committed against citizens of Malawi, correct? Can we then exercise jurisdiction on the basis that the actions were committed against citizens of a state person?
Yes, if it's based on that argument, yes.
What is the provision under the Malabo Protocol in respect of jurisdiction of this court?
With regards to which
The jurisdiction of this court?
temporal jurisdiction?
No, jurisdiction of this court. The criteria, the 4 dimensions that you quote.
Yes.
What is the provision?
The provision is that for the African court to have jurisdiction, it must satisfy all the 4 dimensions of jurisdiction.
Is that provided for the Malabo Protocol?
It was provided for by a case before the African courts. That is,
The Malabo Protocol provides for its own provision.
no, we rely this on a case basis.
I'm asking, does the Malabo Protocol provide for this? Are you sure? Are you sure?
Yes. Turning to our second issue before this honorable courts on the issue of admissibility, it is our position that this case is inadmissible before the African court with regards to the law number 7 adopted by the Parliament of Republic of Kibera and the judgment given by the judge in the Republic of Kibera. And we shall justify this in 2 limbs of argument. On the first limb of argument, we shall rely on the principle of state sovereignty and subsidiarity, and that the domestic amnesty law that was given by the Republic of Kibera is valid and legitimate. It is our position that this case is inadmissible before this court because the domestic amnesty law given is valid and legitimate. And we shall rely on Article 2.4 of the United Nations Charter, where it explicitly mandates states to promote political independence and territorial integrity and jurisdiction. Sorry. We also, on that matter, we do rely on the Article 46H of the Malabo Protocol, whereby it gives, or rather it mandates, it gives the primacy of national proceedings. And so the fact that the amnesty law rooted from the state sovereignty power of the Republic of Kibera, and that the judgment given by the judge who granted the amnesty given to General Chikumbi is still valid. It is also our submission, based on the fact that the sovereignty, state sovereignty that is, and subsidiarity, that in paragraph 22 and 23, we do see that there were conditions. There were conditions given under the law number 7 adopted by the Parliament. And under Article 1 of the law number 7, which establishes the scope of application of that law, is that it explicitly provided that all ongoing investigations and prosecutions will be terminated and any criminal sanctions will be revoked as long as the conditions were met. So this on the face of record, it shows that it was not a blanket amnesty, but a conditional one.
But Article 46, H2 of the Memorandum of Complementary Principle requires that it must be a case that has been tried fully.
Yes.
And a warrant of either conviction or acquittal of the issue. So was this a trial?
Much obliged. To answer that question, we do see as one of the conditions there was a judicial control. So there was involvement of a judge, and before a judge gives a conferment or a decision with regards to the same, there has to be a or rather there was a structure that was followed by that judge to come up with that decision.
So that decision was it a decision of conviction or acquittal? Because that's a requirement in the Memorandum of Protocol. It's not just judicial control, but rather that leads to a decision that is either a conviction or acquittal. So which of the two is this?
So after in paragraph 23, where we see the judge, he confirmed, and under the conditions was that there was the establishment of to fulfill all the conditions. So it's
my issue is when the judge confirmed the decision, was it a decision of conviction or acquittal?
It was a decision of acquittal.
Are you sure?
Yes.
How do you term an acquittal? What is an acquittal?
Or to help it, maybe there's a third option. If there's no conviction or acquittal, maybe
so according to the facts, there was a confirmation.
but the timekeeper says it's true.
We wish to request an additional time of 4 minutes. That's okay.
We'll give it 3.
Thank you. Yes. Can you request the question?
No. So, because a reading of Article 46, H2, okay, paragraph C, in the Memorandum of Protocol, seems to take this position that the complementarity principle, okay, in the sense that if there is a trial that has been conducted that leads to a conviction or an acquittal, okay, then of course the court cannot be able to admit that matter because of the principle of complementarity. But the decision required must be a decision of either an acquittal or a conviction. So I'm wondering whether on granting of amnesty by a court confirmation amounts to either an acquittal or a conviction. I don't know if my question is.
Yes, Your Excellency. And according to the facts pattern, under Article 1, where we see that there were prosecutions done and investigations. So these prosecutions that were done, they were subject to the conditions. And that this shows that the case, rather these cases of these alleged violations were the state of Republic of Kibera was not unwilling because of the presence of Article 1, where it gives that there has to be prosecutions and investigation based on the conditions. And so it is our submission, or rather we contend that General Chikumbi adhered to the conditions that were set that led to the judge to confirm the same.
Okay. Let's look at the jurisprudence of different international courts and tribunals. Has there been any court case that have dealt with a similar situation?
Not really. Maybe I wish to get in on that.
Yeah, there was a reference by the prosecution of the state of Islam Gaddafi and the decision by the International Criminal Court in respect of the granting of amnesty. Okay. Now, I'm wondering whether have you ever addressed yourself to that case?
Yes. prosecution submission.
Only the
Yes.
Yeah.
We also wish to proceed with our argument on the conditional amnesty. We keep note that there was a Truth and Reconciliation Commission that was set, as it is given in paragraph 21. So this confirms the willingness of the Republic of Kibara to even conclude and to prosecute on the same, and to wish that the conditions are not just merely be given, but the procedure to be followed.
I just want in brief, because I know your time, so in brief, have you looked at the ITRC study and what it says in response of amnesty?
Yes, excellent.
What does it say?
With regards to the rules, amnesties are not permissible in international armed conflicts where they bar investigations and prosecutions. Yes, and however, or rather, with regards to the facts pattern here, we do wish to submit before this honorable court that this was not a blanket amnesty. This was a conditional amnesty.
Does the rules indicate whether it's a blanket or a conditional amnesty?
No, it indicates that amnesty. It just indicates that amnesties that bar investigations and
It doesn't matter whether it's a conditional amnesty or not. So in this case, do you think it was right for the state to grant amnesty?
We wish to submit that this was an extra measure taken by the Republic of Kibara to ensure that the prosecutions were just not given bluntly. Turning to our last issue, or rather our last limp of arguments.
You just give you on that summarize.
Thank you.
Those two one and you.
All right. To summarize the last issue on admissibility, we wish to submit before this honorable court that this case is inadmissible with regards to the matter in hand had already been solved in the domestic and regional basis. That is, we see in paragraph 21, there were negotiation processes that were happening. And so since the ceasefire agreement, it's brokered between the disputing parties, that is the state of Arawio and the Republic of Kibara. So this shows that there was a legitimate effort to restore peace and ensure that there was restoration of peace and accountability. And also this shows that, or rather prosecution bringing this case before this court, it shows that reopening of such cases where parties have negotiated as it is required under Article 33 of the United Nations Charter, it shows that it undermines the principle of finality in legal proceedings, and also it disregards the exhaustion of local remedies. We wish to rely on Article 56(7) of the African Charter.
Council, thank you very much.
Thank you.
Your Excellencies, my lords and my ladies, may it please report, as earlier introduced, my name is Cyrus Kariuki, the second counsel appearing for the defense. I intend to utilize the 16 minutes allocated to me to dispense with the merits of the third issue on General Chikumbi's responsibility for the war crimes. With the court's permission, I'd like to proceed. Your Honors, the defense today stands before you not to excuse wrongdoing, but to expose the factual and legal insufficiencies of the prosecution's case. The charges levied against our client, General Chikumbi, require a rigorous application of international humanitarian law. Yet the evidence presented by the prosecution fails to establish the required threshold for criminal responsibility under the same law. We urge this court to uphold the principles of fairness and justice as we exercise judicial restraint. Turning to the third issue, on General Chikumbi's responsibility for the war crimes, we submit that there are no reasonable grounds to convict General Chikumbi of the crimes as provided for under Article 43B, Article 3 and then together with Article 28B of the Malawi Protocol. We do note the submissions of the prosecution as they regard command responsibility. However, honorable members of the bench, we submit that the legal threshold for command responsibility has not been met. We place reliance on prosecutor versus Fiae Gomo, decided for the appeals chamber of the International Criminal Court in 2018, where the case was given as knowledge and reasonable measures to prevent the crimes. Honorable members of the bench, we submit that pursuant to the fact pattern, and particularly the exhibit that has been flagged by the prosecution, we submit that Judge Kumbi had no knowledge of the attack. What is merely shown by the exhibit?
Sorry, I'm having a problem here because you're making reference to the Burma case. But the appeals chamber in the same case differentiates between the standard of knowledge applicable under the Rome statute and applicable under the ad hoc tribunals, which is what the Malawi Protocol actually applies. So the knowledge requirement standard under the Burma case is not applicable to the case before, because they are totally different. Because the knowledge there is ought to have known, here it had reason to know. And the Burma case says those are totally different. So why should we apply the Burma standard, which is not applicable to us?
Thank you for your question, Your Honor. And to respond to your question, also we should place reliance on Exhibit 1. From Exhibit 1, it is clear that there was no reason to know of the attack because, rather, Colonel Demise did not present the facts. Rather, he just informed the general that civilians had been separated in the civilian line. He did not report on the attack. There was no mention of the attack in the Exhibit 1.
But General Chikumbi is the one who actually asked, how many did you capture? So how can he ask how many did you capture if he was not aware of the attack?
Thank you for your question, Honorable Member of the bench. From our submission is that he did not order the attack. That is why he did not feel responsible.
Council, how about the principle of command responsibility? How does it come into these facts? Command responsibility, you was in charge.
Thank you, Honorable Member of the bench, for your question. And as I will go to submit before this Honorable Court, we submit that in as much as he has command responsibility, then there was mistake or facts presented under paragraph 13 of the fact pattern, where we see that the KSL forces were issued with intelligence. The intelligence was faulty. Furthermore, Honorable Members of the bench, the circumstances surrounding the attack are such that they contribute to the mistaken fact. There had been an MPDF warship patrolling the area and it was involved in cutting communication and sea cables. Furthermore, when the civilian liner was instructed to stop, it did not do so. It was further flying the flag of the state of Malawi. Taking all these facts into account, Honorable Members of the bench, it was reasonable for the KSF soldiers to conclude that they were attacking an MPDF warship. That is a military object and not a civilian object.
How then do you respond to the prosecution submission that's invoking Article 51 of Action Protocol 1? That, as a commander, you must take all feasible measures to make sure the object of the attack is a military object and not a civilian objective. In that respect, therefore, they're saying that there were no precautions taken. How do you respond to that?
Thank you. From the fact pattern, it is clear that indeed there was precautions taken of the bench. The first precaution of the intelligence, albeit it was taken in that sense. The second precaution was the attempt to try and stop the single liner. Honorable Members of the bench, how could the KSF members conduct further verification? The single liner was continuing to move. It had to stop for them to try and verify that it was a civilian object. Continuing on our submissions, we also wish to rely on prosecutor versus Kotolia and Markach, decided before the International Criminal Tribunal for the former Yugoslavia in 2012, where under paragraph 64 and 66, The tribunal recognized that mistakes can indeed occur in an armed conflict owing to operational errors as well as identification errors on members of the bench. We therefore urge this court to not convict our client in fully, seeing that pursuant also paragraph 32(1) of the law target provides that mistake of facts that negate the mental element, that is the mens rea, can be used to escape criminal responsibility. Honorable members of the bench, seeing this was a mistake targeting General Kumbi and the PSF, so it was therefore had no intention to attack the civilian population. Starting to the second issue in question, we submit that General Kumbi cannot be held criminally responsible for the war crimes of sexual exploitation. Honorable members of the bench, we're going to be responding to the arguments of the prosecution in two phases. First, that under paragraph 19 of the fact pattern, the evidence that was relied on by the prosecution was video interview that was given by one of the KSF members, that is from the Tigers unit, the women's unit of the KSF. Honorable members of the bench, the prosecution has made no effort to try and verify this interview. In Jawara versus the Gambia, decided before the African Commission of Human and People's Rights. In 2000, the Commission emphasized the need to verify media reports on honorable members of the bench. They have made no efforts, and therefore the admissibility of the video interview is in question.
How then do you understand with the ICT decision about beyond a human rights court, a criminal course in the Adi the situation in life, and the visibility of the video evidence and digital evidences in respect of the destruction of cultural properties?
Thank you, honorable member of the bench. In response to your question, I've been relying on the same case, prosecutor versus Al Hassan, particularly the pre-trial decision in 2019, where under paragraph 198, the court stated that such evidence must be presented in front of the court by the victims, honorable members of the bench, carrying with it a qualitative aspect. Therefore, one interview given by only one of the KSF women does not hold any weight on this honorable court, honorable members of the bench. They further relied on the medical reports that is provided for that was leaked by a media house, honorable members of the bench. The key aspect being leaked and not the admissibility of leaked reports before this honorable court. Also, honorable members of the bench, I also wish to make reliance on prosecutor versus Moscow propaganda before the ICC in 2019 to show that honorable members of the bench, sexual violences require some weight of evidence, or rather require some weight of evidence. And in this particular case, the medical report only shows that the KSF woman was pregnant. It does not prove the elements of rape as is provided for the prosecutor versus Moscow propaganda, that is penetration and non-consensual. It only proves that she was pregnant, does not prove penetration on honorable members of the bench.
But the confirmation studies here, that is only a child states that they need to do that. What is the evidentiary standard before we start?
We did submit that the evidentiary standard is lower than that expected in the trial chamber. However, honorable member of the bench, there is inconsistencies in the evidence provided honorable member of the bench. One of them being leaked, and as provided for in the Bosnia versus Serbia case decided for the International Court of Justice in 2007, provided that for evidence to be admitted before the court, it must be consistent, honorable member of the bench. This one provided is inconsistent. Turning to
I'm trying to find the inconsistency. Inconsistency.
Thank you, honorable member of the bench. The inconsistent is in the fact that the medical report that was provided was leaked, and that further the evidence that has been provided by one of the KSF members was a video interview.
That is not inconsistent. They are all saying the same thing, it's just that they were given by two different sources.
Thank you, Honorable Member of the Bench. The inconsistency is further provided for under paragraph 18, where we see that from that report of the FIA provides that Colonel Denise was a 14-year-old. However, from the fact that under paragraph 30, we see that indeed Colonel Denise was a 23-year-old.
The first will not say that. And we live in poverty.
Sorry,
The first will not say that.
the fact
For living in poverty.
the fact states that under paragraph 13, the fact line.
Yes.
On June 22nd, 2023, the KSF conducted a naval ambush attack in waters around Amoti, led by Colonel Denise, a 23-year-old soldier.
Yes. Yes. And then what does the report say?
The report states that he had not met with the majority, that he was the age of 19. That is person
Are you reading verbatim?
The report, in fact, noted that Colonel Denise, who led the attack, was actually 14 years old, rather than 23 years old.
So in that respect, it means that the report says he was not actually 23, but rather
14. That is,
yeah. So it's not that there is a part. They are saying that he was not 23 because he was 14.
Honorable Member of the Bench.
So they are trying to clarify.
Yes.
So there's no inconsistency.
Thank you, Honorable Member of the Bench. However, as per the records, the military records, as it is provided for under paragraph 13, he was indeed 23 years old. I'm trying to show that the evidence provided by the FIAE are inconsistent with the one given by the records, as well as the military records under paragraph 13. Moving on, Honorable Members of the Bench, to the third crime, we submit that General Chikumbi cannot be held criminally responsible for utilizing the presence of civilians to render certain points for him or military forces immune from military action. Now I'm going to submit in one game. Honorable Members of the Bench, if you turn to paragraph 6, 7, and 8 of the first party, you will realize that there was an ambiguity presented by those particular facts, in that they present that there had been a rise in sea levels that shifted the baselines of the state of Kibara and the state of Maravillo. That of the state of Kibara moving seaward in the sea, Honorable Members to the Bench. Therefore, as has been submitted by the full council, and pursuant to paragraph 2 Article 15 of the United Nations Convention of the Law, and taking those facts into account, it was reasonable for the KSA forces to believe that they were operating under the territory of Kibara. And pursuant further to Article 25 of the United Nations Convention on the Law of the Sea, provides that states may restrict or prevent the entry of foreign vessels into their territory, provided they have national security concerns. And they also admit that because they reasonably believe that they are operating under their own territory, they cannot be convicted because it is expected for them to, they have a legal authority to restrict the entry, and this was done through the seizure, the seamen liner. We make reliance on the Arctic Sunrise case between the Netherlands and Russia decided for the International Tribunal of the Law of the Sea in 2013, where the tribunal noted that national security is a justified reason for states to restrict the entry of foreign vessels into territorial waters through seizing in that particular case.
Yes, through seizing, but not using Shahid. Is that seizing?
Thank you, Honorable Member of the Bench. And it's submit that the fact that a missile was placed into the seamen liner cannot be used as an indicator that the KSF soldiers were utilizing the presence of a civilian. Honorable Members of the Bench, from the fact pattern, it is clear that there is a military presence by both the MPDF and the KSF forces. If therefore, Honorable Members of the Bench, by placing rather the missile, is a way of protecting themselves from attack, because Honorable Members of the Bench, they cannot, there is a military presence by the MPDF and they could attack at any point.
Yeah, but what does IHL say about that? That's basically what my question is. What does international humanitarian law say about a situation where you have civilian and military within the same premise?
Thank you, Honorable Member of the bench. If there are civilians and military, or rather if there are civilians, then they're supposed to be separated. This was done according to the fact pattern. The women and men were separated from each other, the civilians.
In the same vessel,
They were,
which you put missiles.
thank you. I could you clarify your question a little bit?
My question is, you have civilians ownership,
Yes,
correct?
yes.
You throw a missile as a form of seizing, according to your submission. You killing 51 civilians. I'm not sure whether that's your submission, correct?
That is not
You say that states have a right to seize in situations of national security. How did they seize? They threw a missile and killing 51. That's the form of seizing that you're saying.
Thank you, Honorable Member of the bench. To clarify, I'm submitting on the third issue. That after the attack had happened. The attack, as I have submitted, was due to mistaken facts. However, the seizing was way after the attack, Honorable Member of the bench. And the seizing was done and the civilians were separated and there was no attack after the seizing the civilians.
Understood. Now you have boarded the vessel, correct?
Yes.
You separated the male and female inside the boat, inside the vessel. So how then do you prevent the civilians from being attacked?
We prevent the civilians from being attacked by bringing down the missiles on board the civilian.
Then that means you are using them as shield.
No, we are not using them as shield, rather we are trying to protect them. Yes, we are trying to protect them from the MPDA because as I have submitted, there is a military present by the enemy state through the MPDA forces. Therefore, it was very likely foreseeable that an attack would happen due to the PSF being on board the civilian.
If you did not put those missiles, would State Malawi attack the MPDF? Would they still attack based on the civilians being present?
It was not only the civilians that were present at that point, the PSF soldiers.
So will they still attack?
It's foreseeable that they would attack and enemy.
When they went to the Superior Union, what was the statement by the ambassador of Malawi? When they went to have the discussion at the Superior Union, what was the statement by the ambassador of Malawi?
That is pursuant to Paragraph 15, and the ambassador stated that the Republic of Kibara, they noted that the ship had trespassed the territory of the Republic of Kibara, that holding those civilians was within the domestic growth of the Republic of Kibara.
That's Kibara ambassador. I'm talking about Malawi.
He condemned the seizing.
Just condemn? What does this ambassador say?
He noted that. Would you clarify on that particular fact?
I'm asking about the ambassador of Malawi
Yes.
at the Superior Union. Did they give timelines?
He noted that he would give an authorization for the military operation for a magnitude never seen before in the next 3 days if the case did not release the civilians.
So it means basically their only preventive measure was because the civilians were present, correct?
Honorable Member of the bench, we still stick to our submission that they were protecting the civilians.
We are not in dispute to your submission. I'm just trying to clarify the facts. Okay. The only preventive measure why Malawi did not attack the civilian liner was because there are presence of civilians. That's what the ambassador is trying to say. That either you release or you attack. So the only thing that is preventing us is because you have the civilians.
Thank you, Honorable Member of the bench. However, in that same regard, the United Nations Convention of the Law of the Sea provides that states may create their own domestic laws if rather vessels are operating within their own domestic jurisdiction.
We are not in dispute of that, but then we have to look at international humanitarian law.
Indeed.
So what happens when there's domestic law and international law?
In this particular case, honorable member of the bench, it is international law that is being applied to the decision of the court. You please rely on it.
That's Article 27 of the Vienna Convention laws of treaty say. Access cannot invoke its domestic law as a justification. So then they cannot say we are using our domestic law to hold these people in violation of international humanitarian law.
However, Your Excellency, it is not only domestic law being applied, it is also the United Nations Convention on the Law of the Sea, pursuant to Paragraph 25, that provides that they may restrict the entry of vessels in line
Using what?
in line with national security requirements.
Using what?
Sorry.
Using what? Domestic? No. That's what the provision said.
Honorable member of the bench, it does not explicitly state domestic law. It only states that they may restrict the entry.
Yes, I'm referring to the commentary.
Okay.
Yes, that's the reasoning behind the draft. Let me even proceed.
Thank you, honorable members of the bench. The addition, I request an additional minute to conclude on our appearance.
How many minutes?
A minute.
1 minute, please do.
Honorable members of the bench, having come to the conclusion of our submissions, we urge this court to take them into account, including in the favor of the defense, saying that the evidentiary as well as the factual basis relied on by the prosecution is flawed. Therefore, urge this court to decree and declare that it lacks the requisite jurisdiction, particularly for the territorial and temporal jurisdiction, that the issue presented before this honorable court are inadmissible due to the principle of state sovereignty, and that finally there are no reasonable grounds to believe that Mumbi can be held criminally responsible for the alleged war crimes. With that, we see the floor back to the bench.
Thank you very much. And unless you have something additional to say from your side, you also have a right to say you've rested your case and you have nothing additional.
Your Honor, these are 3 weeks for budgets and shall be personal. Your Honor, the defense has stated that this court lacks territorial jurisdiction. And the basis of saying so was that one, it has actively participated for a multi-area based on its economic interests. However, we wish to state that the reasoning of the Honorable International Court of Justice in Nicaragua versus Honduras 2007, paragraph 172 stated that for you to claim exclusive sovereignty over a territory, you have to show your capacity to have exercised exclusive sovereignty over the territory prior to the dispute of the title to the territory continuously. In other words, we're looking at before the dispute in issue over the sovereignty of a multi-territory under the fact pattern paragraph 9 was raised, was the state of Kibara exercising exclusive sovereignty over a multi-territory. And the answer was answered by the President Banjuma, paragraph 8 of the fact pattern. The answer was no. On the issue of admissibility, contrary to what the defense has faced, we submit that under particularly in prosecutor versus Al-Gaddafi of 2014, paragraph 58, the International Criminal Court reasoned that what is required is a res judicata effect to the trial, investigation, and prosecution issue. In this case, we're looking at when the trial began, and the trial come to a point of completion such that this court cannot exercise jurisdiction. And the answer was given against the defense. They did not. On the issue of the civil life, we submit that under Article 91, the nationality of a ship is attached to the flag state. Under the first paragraph 13, The famous liner was flying the flag of Malawi. Hence, it has the nationality of the state of Malawi. The next 30 seconds are remaining. I wish to offer a closing statement. Your Honor, justice is not just about the letter of the law. It's about the spirit of the law. Today we have appeared before you as a prosecution, not just as mere legal counsels, but as advocates of justice. We are advocates of justice for 250 innocent civilians whose only mistake was to board an innocent commercial vessel for the purposes of sale. We are advocates for 51 innocent civilians who now lie buried, only to be commemorated as individuals that come from an attack by the defendant. And we are advocates for young children and girls who, in the name of patriotism, brainwashed by the defendant to believe so, ended up to be ruthlessly sexually violated. Your Honor, do not stand unless these atrocities just pass by. The defense has only said that we are sorry and we are apologetic and sympathetic for these atrocities. But what can an apology do? What can an apology? How much can it suffice for all these atrocities? Do not stand by these injustices. Thank you.
Thank you. Any final words from friends?
And thank you once more, members of the bench. Here to issue the points, sign battles for the defense. The learned counsel for the prosecution provided that the flagship principle, the one that applies in this particular case. However, honorable members of the bench, Article 92 of the United Nations Convention on the Law of the Sea is clear. A state a vessel shall only fly one flag from one state, subject to the law of honorable members of the bench. It is supposed to fly the flag of the state where it is registered under. Therefore, it is immaterial that the seaman liner was flying the flag of the state of Malawi, because as provided for under the law, it is supposed to fly the flag for Kibali. On the second point of rebuttal, the learned counsel for the prosecution stated that because of the active participation of the state of Kibali with regards to their multi-region, therefore lacks exclusive jurisdiction. However, honorable members of the bench, we submit that pursuant to the fact pattern and pursuant to the law, particularly in the statute set for the European Court of Human Rights, it is not essential. The court stated that exclusive territorial jurisdiction or rather sovereignty is not a requirement for honorable members of the bench. Rather, it is some certain level of effective control. What was considered in that particular case was a military presence as well as active participation with regards to the territory in question. Therefore, honorable members of the bench urge this honorable court to find that it indeed has the jurisdiction and there is really grounds not to rule on this case. With that, honorable members of the bench, I see the floor back to the bench and thank the bench for its indulgence.
Thank you very much. The bench will retire for about 15 minutes and we will come back with my public.
Help me with the books.
We should study hard, eh?
Help me with this.
We should study hard, eh? You can't be clerk in the Supreme Court and you fail to work here. I think we can evacuate the place.
The session is not yet done.
Really? Okay.
No problem.
And then you gotta keep it on your phone.
We might be charged with contempt. Clerk are powerful. Don't forget where you are. Then we say clerk associate with the audience. What's up them?
Especially in okay.
My God, you have to take it. Oh, right. Yeah, as a baby serving us. Thank you very much. I'll take the gaze at 20 minutes. I missed it.
Just this one, not today, because we've been discussing inside there. Want to save time because his lordship has another engagement right after this. So, two things. One, I know there's a team that has won the best memorial. So, and I will not mention, you get to know, right? And I know they are here. So, first, it's important you guys get close because you're going to be doing these things very tough. Secondly, I'm also going to ask that there's going to be a period of photo sessions. So if you really want to be part of those photo sessions, you need to be closer because we're going to be taking everything very fast. Okay? What was the other thing? Yeah, each of the teams, because I know the teams that came, I think every team from South Sudan, Ethiopia, Kenya, and Uganda. At least a drill needs to be closed once they call the institution so that it's quicker, because he has to go faster. And for the participants, relax. I know the winner, but I cannot mention. So,
Thank you very much. We are back and we are going to go about the budget. This is how we are going to do it. Each of the members of the bench is going to introduce themselves to you and then make a very few brief remarks on what is going on. After that, I'll come in and wind up and we'll give the budget. We have agreed on the order which we will speak, and I'll call upon our first speaker to the floor.
Good morning, everyone. I hope you're all well. My name is Tracy Nabale. I am an advocate of the High Court of Uganda, and I also work with the Women's Pro Bono Initiative. It's a civil society organization that uses legal tools to advocate for the rights of women and adults in Uganda, and I work there as a legal officer. So to the prosecution and defense, thank you so much. Yes, I know it is an honor for you to reach the finals. I know you had very many rounds that you passed, and I just want to congratulate you for reaching the finals. I know you were very articulate, you understood the facts, you were actually relating them to the law, you were persuasive. I just want to congratulate you. But maybe to the defense, I was present at the semi-finals, and if my mental right, you were in the presentation side. And going forward, I know you're very young and you're going to be in business. Going forward, maybe you can balance in your preparation both for the prosecution and the defense. But otherwise, you all did well. Thank you so much. I'll end them.
Thank you for the comments.
Good morning. My name is Solefe Mugweno, and I'm the Assistant Director of Programs at University Initiative for Academic Excellence. I'm a lecturer of Public International Law, International Humanitarian and International Humanitarian Law. I'm also a consultant with the United Nations Institute for Economic Research on the application of international humanitarian law on autonomous weapon system. And I'm the author of the book problem. So probably that leads to the question that was during the my comments to the participants. I'm sure you had prepared this for so long. That 5 teams across Africa, the 4 of you managed to find. So if you'll be proud of yourselves. I know it has taken sleepless nights, a lot of work, research, and even institutions last year to be able to represent them. What my advice will be is keep doing what you do. International humanitarian law has become more important than it has ever been. You know the current affairs, what is happening in the world, and therefore, international humanitarian law is needed, and we need more experts in this area, and therefore it's important for you to not just stop here, but take it from here and going forward. So that will be my advice to you, and thank you very much. The round was very wonderful, and I wish you the best of luck.
Thank you very much. Next.
Good morning, everyone. My name is Jacob Jim Rakish, and I work with the International Committee of the Red Cross. We are the custodians. We both are the custodians of the International Humanitarian Law. When you see the protocol, the Geneva Convention, things like I said, so that's what I do. I work as a manager for communication prevention, among which is I'm in charge. I'm the one who organizes the Moots. For the students who have been participating in the Muslim. So for me, today it's been a privilege that I'm coming in from the other side, not as an organizer, but I've been enjoyed so much. And so I'm also a lecturer of law. I teach human rights law, I teach jurisprudence, I teach IHL, I teach health and law. So it's a privilege for me to be here. And so to the students, as I for the last 15 years that I've been participating in the Muslim, I see over time that students are becoming better and better and more better. And I've been impressed. I kept on shaking my head and I'm like, wow, these kids are making great advocates. By the time you're done, you'll be really great advocates because I see you understand the issues we comprehend. And like my colleagues say that IHM is becoming more and more interesting. We see new ways of methods of fighting that are coming up. We're having new technologies being invented, and unlike the previous early years where we had human beings, now they are not human beings. So we're having new technologies of fighting that, and of course, we are testing our principles of IHL and how they are applicable when it's not human hand in it. So it's very interesting. And so for the students, I really wish you the best. This is just a start, by the way. Perhaps even I would encourage that maybe some of you could consider doing IHL at a higher level as master's PhD students so that you can really guide us in some of the emerging issues that are coming up. So I wish you the best, and the teams are also impressed by all of you guys, and specifically for the defense. And I advise you to be more prepared and then work together as a team and all that. So you could see the really, it seems like you were not really prepared for that side. And like my colleague said, you had watched you present in the opposite side of the constitution. Perhaps you are now used to my constitution side and the other, and where they put your mind to it. I wish you the best. And that was a different, thank you so much. And I wish you all the best. You can have to go back home because I know you're all working in Uganda. So I wish you the best concept anyway, your countries. Thank you.
Thank you very much, Patricia. It's on behalf of the Chief Justice of Uganda that I welcome all of you to the conference. And thank you very much for honoring the Supreme Court of Uganda and the Uganda Judiciary bringing this new competition here. Thank you very much, the organizers. We thank the participants. Just to declare, I am a patron of Cavendish Law Society. I'm an alumni of Makerere University Law School. I'm also an alumni of University of Iowa Law School. I'm also an alumni of Pepperdine Institute, Strauss Institute for Global Justice. I am a parent, finally, of Uganda Christian University Law School. Just to declare my interests in all this. But glad to see that two universities made it to the final, and I would like to commend you for having made the attempt and succeeded in getting to the finals. Of course, I also congratulate all the participants from the very beginning. Allow me in a special way to introduce to you some students from the United States who are attending the Supreme Court of Uganda. Maybe just stand up, a few of them are here. We have a relationship with Pepperdine Law School for the last 10 years. they've been sending students here to do internship, and Pepperdine Law School students helped Uganda introduce labor gaining in this country, and other aspects of the alternative dispute resolution, which now spreading across the continent of Africa under the Africa Chief Justice's ADR Forum, for which the Chief Justice Alphonse Kigamayo Winito of Uganda is the head. We thank you, and I think the level of debate is quite high. One of the biggest things about advocacy is that you need to be very steady on your feet. So there will be two kinds of judges. There will be the kind of our brother there. They will pepper you with questions you almost will not settle, and you actually may be tempted to move off your script and just answer the question. So you have to be very, very ready to be coming back to your script. Then the other kind of judges, they will let you say whatever you say, they will just be noting, and then they will put it out. It's okay in the way, but you almost have to know which judge you are appearing before if it is just a single judge. If it is a panel, definitely you will expect to be asked many, many questions. And so the advice is you always have to be steady on the feet. Don't get ruffled or rattled by the question. Don't get irritated. You handled it well, much obliged. Same with yours. With due respect, sometimes even though internally you are disrespecting the person, but at least we are not able to see that, but we are able to hear. So much obliged with due respect, and we'll have to always make part of your responses, and you did that well. Time, at the Supreme Court especially, time, we are not tolerant of going over time. Once they say it's time, they will either shut you up rudely, or their lordships will just not be writing what you're saying if they don't right. So you will basically be speaking to yourself. So once they set time, unless you have asked for extra, they are giving you one with that extra goes off, then you have to stop. So the important things are you summarize the facts, you apply the law to the facts. We had questions, what are the laws if you relate to